It is often an afterthought in the back of our minds, writing a will. If something were to happen, though, who gets your belongings, your money? What about your debt? Right now, attorney and counselor Justin Irvin is here to answer those kinds of questions. You can text your questions 336-379-5775. Again, this is text only. Do not call. All right, let's take a look at what is going on with your questions. All right, first and foremost, the question that we get so often, let's put up that first question so that we can ask it. And I believe it happens to deal with debt. Does my stuff go to my spouse and my kids?
Well, if you die without a will, then each state has intestacy statutes that direct who is going to handle your estate and where your stuff is going to go if you don't leave behind a will that you prepared. So if you don't leave behind your own will, then our state legislature has made a will for you. And it tends to be a one-size-fits-all approach. The spouse does have priority as far as inheritance under our intestacy statute is concerned, but they don't automatically get everything. Your spouse might end up inheriting and co-owning your assets, maybe even the home in which they live with you, with your children or with your parents. And that could be an awkward situation, to say the least. You also want to think about whether your children are minors. Minors can't own things like real property on their own. And so that could throw them into a sort of guardianship situation where someone has to go to court and not only administer the assets that you left behind, but also administer the assets that your minor children inherited from you. And that can get to be cumbersome. You'll also want to think about if you have a blended family. Do you have children from a previous relationship, or does your spouse? And that can introduce other dynamics that could complicate the administration of your estate. Your will is you not only get to say who is going to administer your estate, but it's also who gets your stuff. And you can also nominate a guardian for your children to take care of your children after your death if the other parent is gone as well. And you'll also, in addition to making a will, want to think about assets that don't pass under a will, things like life insurance and retirement benefits that have separate beneficiary designations, and even other assets that pass maybe because of joint ownership.
Okay, I can bet that a lot of people out there, their eyes just got like really, really big when they heard that answer, because they're thinking to themselves, I just thought it would just be taken care of and it would just be passed down to the next person. So it's good that we're doing this. All right, this text question says, my partner died and didn't have a will or power of attorney. What do I need to do to sell their car and close out their bank account?
Well, first of all, I'm sorry for your loss. And secondly, I hear you referring to this person as your partner. And I'm going to assume that that means that you weren't married to this person. And unfortunately, North Carolina doesn't recognize relationships other than marriage between two people who are romantically involved. And if that car was entirely in your partner's name, or most of the time, if it was in your name and your partner's name, then you're going to have to make nice with their family of origin, the people that the law recognizes as their family, and cooperate with them to deal with the car.
And that gets messy. Okay, what about the bank account?
Yeah, bank account, same thing. Bank accounts often do have what's called a right of survivorship on them. If you have a joint bank account with someone, there probably is a right of survivorship, and that might become your money automatically when that person dies. It's still going to be subject to the claims of their creditors, subject to their debts, and not 100% of bank accounts have a right of survivorship. So you'll want to check with the bank on that.
All right, this text question says, we have wills written by a lawyer in Henderson, North Carolina. Do we need to have them rewritten for our new address?
Wills and estates and things like that are creatures of state law. So if you had a will made in North Carolina, you don't need to have it redone simply because you moved to another place in North Carolina. But that said, the fact that you moved suggests to me that something about your life has changed. Maybe you've sold a house, maybe you've bought a house, done both, gotten a new job, brought some new people into your family through marriage or adoption or something like that. And even just the passage of time, all those sorts of things suggest to me that maybe you just need to sit down with an attorney and review your estate plan, simply because maybe it's more than 5 to 7 years old.
Okay, this person says, can you leave your spouse out of your will?
Under certain circumstances you can, if you have a marital agreement with that person, something like a prenup or a postnup, or even a separation agreement. Spouses have good protection under North Carolina law and have lots of rights to each other's estates and to their real property as well. And so you can make a will and cut your spouse out of it, but your spouse is going to be able to exercise certain rights and might inherit from you despite what your will says, unless you've got that agreement. So it's worth thinking about, worth talking to your spouse about, maybe, and worth talking with an attorney about.
All right, we're going to continue to take your questions. We're going to take a quick break, and we will be right back.